Good morning and a warm welcome to My2legalcents session of today to Carlo De Lucia, who I have the pleasure to know since a few years, an Italian qualified attorney and solicitor in England and Wales, currently based, save any mistake from my side, in Barcelona, so in Spain, with huge experience in as both in-house counsel and private practitioner and consultant in international construction law. You have been working different jurisdictions. I've just read from your CV experiences in Europe, of course, but also in USA, in the Middle East, in South Africa. And please feel free to integrate any omissions from my side. And for all these reasons, the My2legal sessions of today will be dedicated to international work contracts in the context of both civil and common law systems, with a specific focus on FIDIC and EPC contracts. I will not steal any more time. I would just want to say that when we talk about FIDIC contracts, we talk about commonly used template contracts intended for use in relation to different categories of work, in use in different jurisdictions. Just to remind that FIDIC stands for Fédération Internationale des Ingénieurs Conseils, and we'll also talk about EPC contracts, which are also standard contracts, where EPC stands for Engineering, Procurement and Construction. So my introduction ends here. I really appreciate your time, so to share your experience and reflections on this important subject with us, and just leave you the floor. Can you please I will just start asking you to elaborate a bit more about these two kinds of contract, so the FIDIC and EPC contracts I've just mentioned, according to your experience. Thank you.
Thank you very much, Avvocato Pappalardo, Andrea, for the opportunity to tell you about a little bit about my experience, my experience of life, which is quite extensive, because I started as a private lawyer for working in courts hearings for almost 10 years, and then I completely changed my profession, because I joined an engineering company, working in-house in various roles, as a general counsel, as a legal counsel, as a contractor manager, and so on. The passion of energy moved me towards this opportunity, because I had the opportunity at the beginning to work for the spin-off of Alstom Power, and I was attracted by renewables, which is an area that I like very much. However, the circumstances of the life drove me towards constructions, oil and gas, not only energy production, but construction of gas. Just briefly, I had the opportunity to go through very different kind of contracts, not only EPC contracts and FIDIC basis contract, but also other kind of agreement, such as NEC3, which is a standard that is used for nuclear in particular, and this is the opportunity to look at these different kind of contracts I had was again from different side, because sometimes in my life I was working from the side of the owner, so the owner of the project. Sometimes I was working from the side of the EPC, the contractor, and sometimes I was working from the PMC, so the company that was organizing the project management control of the entire project. EPC, interrupt me if you like.
Please go on.
EPC is the more flexible standard, and is more commonly used, obviously, for international projects, and gives a lot of flexibility, especially when the owner is preparing the EPC, because it's ability to put terms and conditions that are favorable to the owner is obviously in the EPC. However, in the construction world, FIDIC, which is the standard developed by the authority you mentioned, is a standard collaudated and used in many projects. FIDIC has different declinations because there are several books of FIDIC based on colors. So there is the white book, which is linked to the civil works, but the most popular are the red books and the yellow books. One is more favorable to the EPC contractor, and well, more favorable is helpful for the EPC contractor. The other one is more helpful for the owner. FIDIC has many standard clauses, and in the negotiation is very easy because you don't need particularly skills to negotiate. You can just deviate from standard clauses, but it gives a lot of guarantees in terms of execution and in terms of enforcement, because all the arbitration is ruled under the FIDIC contract. On the other side, the EPC, as I said, is flexible, but you have to negotiate everything in the construction phase. So you have to negotiate financial terms and conditions, operation, applicable law, jurisdiction, arbitration. This is very open to the negotiation field. And let me say, and then I give you the word, depends also in which environment you are negotiating, because if you are negotiating in Middle East or in South America, obviously FIDIC is not so popular. In Europe is the standard applicable for all the major company and is aligned to the Code Civil, the principle of civil law based in Europe. On the other side, EPC contract has no limitation of jurisdiction in country because it is left to the free negotiation
of the parties. Sure, it's very interesting, the reference, of course, to the context where we are closing the deal and the negotiations which are needed, depending on whether in a certain country people and companies are used or not to use a certain kind of contract. However, independently from this, there is, since we are talking about templates and general conditions, depending on the specific country and specific situations and the kind of work to be executed, surely there is a need of coordination with the local or the general conditions with the local
jurisdiction,
specific compulsory local provisions. So since your experience in so many countries, and as I was saying at the beginning, you are both an Italian and qualified lawyer and solicitor in UK, in England and Wales. Can you just, should you choose one of the elements which are very important or commonly discussed, when to coordinate or to adapt the general conditions to the specific local provisions? What comes to your mind? Let's
yeah. I always say that the approach should be the one that Robbie Williams suggested in Carpe Diem when he stand up on the desk, because you have to look at the contract from a different point of view. So if you look at the contract, the EPC contract from the common law point of view, which is usually what happened, because these big contracts are negotiated by international law firms that have a strong common law background. You may miss something, especially if the jurisdiction is the jurisdiction belonging to civil law, or a mixed of jurisdiction, like in countries of Middle East, where there is a Sharia law, but there being, like in Iraq, the influence of civil law. So having the opportunity to think about some principle of civil law allow you to look at the other side of the moon. And I make an example, two examples. I had experience on a contract in Belgium, in Antwerp, EPC contract, and the advice was basic to, because of breach of contract from the constructor, to suspend payment. And I was a little bit worried because I wanted to investigate if suspension of payment was in the silent of contract, was under the Belgian law breach of contract itself, or was allowed, because in this case, suspend payment would have triggered another breach of contract against the breach of contract. Another case was with an Iraqi contract regarding a big plant of moorers. And in this case, I made an analysis in terms of consideration, because obviously consideration, which is a main concept in common law and is the basis of the contract, has a different interpretation in a civil law. Because in the civil law you have to look at the premises of the contract are not so relevant as they are in common law, for instance, and also the level of negligence is have been interpreted in different way. So, just coming to your question, and beside that, the culture of the people you are negotiating with, because when you are negotiating with Indians, there are different behavior from Arabics or from people of South America, or Turkey. So you have to consider any aspects of life.
on the top of the legal approach in terms of applicable law, for instance, which of course has an impact on the clauses themselves. There is also a reflection to do in terms of cultural standpoint, depending on where you are.
Exactly.
That's really interesting to know, and thanks also for your precious examples, thanks to your experience. The last thing, going a bit beyond the specific issues which concern specific countries, let's come back to some universal needs according to the current scenario, and I'm referring to in particular to the need to protect the global environment. In light of the importance of the construction industry in the world, and in light of the even more important, the paramount importance of the protection of the global environment, is there any new issue on the table, any new approach in terms of sustainability, which is in discussion? Do you have any idea on this?
Yeah. Well, in a world like that is running big risk, I think everybody of us, you as an external lawyer, us as internal, had to give a contribute in any kind of advice. So sometimes, just to go to your question, restrictions, there are restrictions in some countries, and in other countries there are less restrictions. There are restrictions, for instance, if there is involvement of investors, because they report to obviously to high level of authority. So when you have a project finance and you have this, and you have a spin-off step-in clauses, maybe you have an high attention. There are restrictions in terms of what you are building, because if you are different is if you are building obviously an hospital or a port, or if you are building oil and gas plants in the Middle East, or if you are building an automotive manufacturing plants in China. And sometimes environmental law is a field that is very close to ethics and compliance, because authorization and respect of applicable laws trigger some relationship with authorities and with officers, and in some countries you have to be strict and comply with the principle of our, let's say, which is not better, but our democracy principle and respect of human rights and in general.
Thank you. Really, thanks again.
Thanks, Andrea.
We are going to conclude, just saying that whenever you will wish, I'll be very happy to go on discussing together about this topic or about other topics of common interest. These sessions take place normally regularly, and so it's a way also to share, of course, professionals' experience in different subjects, in different languages, and in different countries. So thank you again.
Thank you very much, Andrea, for the opportunity.
See you soon.
And I hope to see you soon. And thanks.
Thank you.